I'm Julie Bartkey with this Senate update. Should state legacy dollars be used to purchase land by using eminent domain? The answer is no, according to legislation carried by Senator Dave Senjum. His bill was heard on Tuesday in the Senate Environment and Energy Committee.
It really gets to the question, in my view, Mr. Chair and members, is whether or not, as we appropriate the use of legacy money for parks and trails in Minnesota, should that money be used in conjunction with a eminent domain proceeding? I think probably most of us would just instinctively probably say, no, we don't really want that. I would then suggest maybe the next question would be, as we would use money for parks and trails in Minnesota, and specifically legacy money, should that be money used in conjunction with even the threat of an eminent domain proceeding? And I think that's maybe the core question here as you ponder this bill. Last year we did something similar to this with respect to habitat funding and the use of legacy money. And so in the course of that event, or the course of that proceeding, you cannot use legacy money anymore in conjunction with an eminent domain proceeding for habitat money, or land, I'm sorry. This year I wanted to bring this forth. It was part of last year's bill as well. We held it over so we could have a more prolonged discussion about this with respect to parks and trails. And I think you're going to find, as the witness list indicates, that local government, while they will, and even perhaps state government, while they will tell you that they either very seldomly used or don't want to use eminent domain as part of any kind of proceeding relative to a park or a trail, they want that in their negotiating toolbox. And again, that's getting to the core of the question in my mind. Do we even want to have eminent domain as a negotiating threat as we deal with landowners, whoever they might be, on a park and trail that involves the use of legacy money? So that, I think, kind of outlines the crux of the issue from my perspective. Senator Nelson is a co-author of the bill, and she may have some comments as well.
Sure. Welcome to the committee.
Thank you, Mr. Chair, Senator Senjum, and committee. And I am pleased to co-sponsor this with Senator Senjum. And this is born out of an experience that we talked about here in this room at this table, I think it was last year, with your committee. And at that point, I had talked with you about a very narrow issue regarding the ability of a township to trying to stop a county from overriding the township in regards to park mapping. And it was kind of a new concept, I think, for this committee, certainly a new concept for me. But an issue that happened with my constituents was the county drew a map, much like we would do a transportation map about where they plan to move in the future. And this park map encompassed land of some of the folks who are here with us today. And the intention was, once that map, that line was drawn, and at some point in the future, not yet determined, the county would want to purchase that land for a beautiful state park. It's on the Root River. It would be absolutely wonderful. But the issue was this mapping and, in a sense, limiting what the property owners could do with their own property until the county decided it was going to put out an offer on the property. So it's the issues are the same, very similar in terms of the government's role and private property owners' rights. And so I appreciated Senator Senjum allowing me to revisit this with you today. And so if you'll recall, the proposal that I had brought forth was a very limited one, and not necessarily, I'm not saying it was the best, but so you have kind of two different views here. The proposal that I had talked about was specific to Olmsted County and the Root River Regional Park. And I don't know that the state wants to do that on an individual basis for every county that might want to be expanding into townships. or expanding parkland into townships. But on the other hand, then we have Senate File 122, which is a more broader scope, which is policy statewide.
And I went through this with my family when Dakota County 2 years ago tried to take our property away by eminent domain. Our property was considered the sister's property. It was very much televised nationwide and locally. And we had worked with Dakota County for 2 years because they wanted to put the Mississippi River Regional Bike Trail through our property. And we finally decided, okay, we'll allow you to take 1.8 acres and make the trail go through our property. But then when it came down to it, trying to find out what they were actually going to offer us, we were told at their county commissioners meeting that they wanted all of our property. And we had 10.41 acres, and we were told by the judge that we had to negotiate with the county, and that if we didn't negotiate with the county, that they would take all of our land because the law says they could do this. So that's what needs to change. This can't happen to anybody else. I mean, it was devastating to our family. They ended up, we had to come to a negotiation agreement with them. Otherwise, they were going to take everything. And what we ended up doing is selling them outright the 1.8 acres. And then they forced us to put 6.6 acres, which included our marina, into a conservation easement for 20 years. And then after 20 years, they would come and take or pay whatever was left to our children and our grandchildren. And then they said that we could keep 2.2 acres where our homestead was, and that after 40 years, they would come and buy that with whatever it was worth at the time. So it's just pretty much devastating to our family. We had to shut down the marina. We can't earn an income on it at all. And we can only use the marina and the docks for our own personal use, but nothing else. So really, they ended up taking all of our property, whether it be immediate, 20 years, 40 years, it doesn't matter. They took all of our property. And my neighbors, Lauren Sorg, Will and Lauren Sorg, and William Sorg, Randy Sorg, all the Sorgs, they could not come to a negotiation or agreement with the county. So when they went to court, the judge took everything, or gave them everything. So all he got left with was a little piece of property that has a cabin on. So when they say that you need to negotiate, if you don't, you're gonna end up losing everything. And it shouldn't be that way. That's just not right. I don't know, I swore that I would try and help whoever has to go through this eminent domain stuff, because it shouldn't happen that way. The property was in my family's name since 1960, and why should we have to be forced to give up our land so that they can put a park or a bike trail through it? The bike trail we were okay with that, not really, but we ended up agreeing to that, but then they wanted everything, and our property was in their master plan. It had been in their master plan since 2002. So it's really hard to look at a master plan and see your property. They had intended on putting picnic shelters, a restaurant facility, docks that would have houseboats for rent that would never leave the dock, so kind of like a camper cabin on a dock. So all this stuff was in their master plan, and it still is in their master plan, which I don't think that's legal either, but I don't know. But that's what I'm here to tell you. So it really is important to me that this not happen to anybody else. It was really devastating. So, thank you.
Sergeant, thank you for your testimony. We do have the amendment before us now. Senator Rosen moved this as an author's amendment to put it in the shape the author wishes. On the Rosen motion to adopt the A1 amendment.
Mr. Chair, could I just...
Sure, go ahead.
In one sentence, this would allow for a so-called friendly condemnation, which is somewhat would occur in some cases due to, frankly, tax reasons. If there's a willing situation there and condemnation isn't advantageous for tax reasons, it would allow it. The other thing, it takes off or negates the previously condemned situation. So anything that's happened in the past, this is all looking forward.
Okay.
If there's a condemned property that's already been condemned, this does not. You could use legacy money on it.
Okay, on Senator Rosen's motion to adopt the A1, all those in favor say aye.
Aye.
Opposed? Motion prevails. Please continue with the witnesses.
Hi, thank you, Mr. Chairman and the committee and the senators. I appreciate them also sponsoring this bill. My name is Deborah Kaldenberg. After listening to Joni, I guess I'm choking up. I have 2 children, a son and a daughter. Both are married. My son farms with me on my farm of 386 acres outside of Rochester in Homestead County. This is just a small farm, not one of these big farms. My farm also borders the Root River Regional Park, and this is what we're talking about. And I guess at this time, you'll see 3 of us have wore our t-shirts. We all got a letter from the county park in October 2013 stating that they would like to put our land on official mapping, those quotation marks around official mapping. That's what they do for highways, not parks. And so we got together. The county had said that they would meet with all 29 landowners, which is about 500 acres of private property, and meet at the Masonic Lodge in Pleasant Grove. So we pounded doors, telephone calls, talked to neighbors, the newspaper, and created these t-shirts. So if you can go back on the video. Oh, I'm sorry. Thank you. And went to the Masonic Lodge. We had that standing room, not even standing room, only in the Masonic Lodge. It was a rainy, cold November day, and we had probably 200 to 300 people standing outside the door. We also had petitions, so I got proof that there's 300 people that was there that night. Yes, the county board did back down, but that doesn't mean they're not going to find another way to take our land from us. And I use the word take because when you see eminent domain, that hurts. My husband's parents bought the farm that I am on, bought it in 1937. My son grew up knowing someday he would be able to farm that farm. Today he comes to me, he goes, Mom, we could sell that 35 acres they want for $700,000. Let's take the money and run. That is part of his heritage. He goes, I don't want to lose it. That 35 acres, I said I own 386 that I farm. 30 of those acres are tillable. They bring in our income. It feeds my family. My son's married, so it feeds 2 families right now. And we make ends meet. We don't have big grain bins or anything like that. It's just a small farm. He wants to grow. I do have one challenge. He does. We have all big farmers around us. So if they're taking away this 35 acres, I do not know if we can hold on to our farm because we wouldn't be able to make ends meet on that. So in with this bill, you do have my testimony that I was reading. I skipped over some parts, but I'm hoping by this bill at least the county would stop to think, hey, if we want to use legacy funds, we're not going to use eminent domain. It's a baby step that we've wanted to take on that. And the other part of my testimony just explains how I have worked for 30 years. I worked uptown to keep this farm, so I could retire on that. And if I lost the 35 acres, I probably could not live there either because I wouldn't be able to afford it. So I thank you for your time.
Thank you very much, Ms. Kaldenberg. Next, Ms. Baruch.
Okay,
Ruth?
thank you, Senator Marty, committee, and senators. I'm Kathy Baruth from rural Stewartville, and I own 35 acres of land near the Root River Regional Park in Olmsted County. I feel it's important that money from Parks and Trails funds not be used to acquire property by means of eminent domain. Park land should be acquired through negotiations with landowners. not through forced acquisition of land from private landowners. In 2013, Deb kind of described what happened. I'll briefly say my property was threatened through the proposed official mapping of properties to expand the Root River Regional Park. And the official mapping would have affected 29 landowners near the current park. And if it would have become official, like Senator Nelson said, then it would have devalued our property because the county would have had rights to acquire once we ask for a building permit or such. Our family has owned this property for many years. It's really become a family legacy, raising our family in this beautiful valley by the Root River. We've had wonderful family times of picnics, bonfires, camping, hiking, entertaining friends and relatives. And it isn't just a piece of land, but it's really a legacy for our family, a dream for our children to continue to use, and grandchildren too. And we've given up many things through the years that other families might have had: nicer cars, family vacations, eating out more, and those kinds of things, because we've wanted to maintain this land, which has been a beautiful part of our family life. Now, in Olmsted County, there are many acres of parkland already, and funds would be much better spent to improve the quality of the parks that already exist. Now, the county was very good with working with us, and they said they would not use official mapping or eminent domain for park acquisition. But we don't know in the future as things evolve, and we want, my family wants this land for many years. There may be other families that will desire to sell, and if the county can negotiate with them, then that's reasonable, but it shouldn't be done by force. So I ask you to support this legislation, which would eliminate the use of eminent domain with Parks and Trails funding. Thank you.
Thank you very much for your testimony. Mr. Nagel.
Yes, Chairman. I appreciate the time and effort that you put in to be here, but I've got to suck on something, I think, to get my throat cleared out. Anyway, when I grew up, I grew up on a farm, and my dad owned the farm, and I wanted one. And right at the moment, I'm by Stewartville, right next to where they, next to the park, and have 250 acres there. And it's land similar to what the park people are looking at. And I wasn't, at that time, told that my land was in the park. But when my neighbors came up and told me that what was going on with the mapping situation, I couldn't believe it, because I grew up with, if you worked for the land, you bought the land, it was your land. And here they could come in and do the mapping on the property or on your land. And if they'd mapped it and you went in to get a permit to upgrade your house or upgrade anything, they had the right to come to send somebody out to appraise it, give you that money, and send you on your way. And I didn't grow up that way. I don't understand why in the United States, they can come in and take your land just because somebody wants to put a park on it. And that's why I agree with what's written here, and that eminent domain should not be used for a park. I can see it on a road, because when they come by my place, they came out and talked to me about it, and they took land off my property for the road, and that was fine. But for a park, I don't think it's legal or right or anything. Thank you.
Thank you, Mr. Nagel. Mr. Sackett, welcome to the committee.
Thank you for letting me have the opportunity to speak. Jim Sackett's my name. I'm a construction worker. Before Minnesota was a state in 1858, my family, I'm choked a little too, had the farm. 5 generations of my grandparents are buried 1 mile from where Olmsted wants this park, Pleasant Grove Cemetery. I'm so proud of them, I have my lot already there. And you want to steal, or I'm sorry, you guys, the county wants to steal these acres from us. It's my entire family legacy there. What's left there, we've been there almost for 200 years. And in talking with the DNR, before they've been at some of the meetings we've had down there, they have actually said that they don't purchase land through eminent domain. They pretty much hit willing landowners. And I am not against that at all. The legacy funds should be used for that kind of stuff. Okay? In 2007 and 2008, when that legacy funds came out, as Dave pointed out, I voted for that, assuming that it was to fix parks, trails, all that kind of stuff. Never, I did not know that it was going to be able to steal the land from me. I didn't know I'd be voting to pull the rug out from underneath myself. And I'm hoping you guys vote for this SF 122, or maybe put the legacy funds back on the ballot and tell all the voters the truth about it, what it can do to them down the line. So please, pass this and do the right thing. Thank you.
Thank you for your testimony, Mr. Sackett. Senator Osmek, you had a...
Yep. Thank you, Mr. Chairman. To the authors, let's put the shoe on the other foot. Let's say that we have a parks project that is legacy funded and everybody agrees it's a great project, it's a great trail, it's a great park, whatever the case might be, and you have 99% of the property and you have one person that won't under any price sell their property. Can you give me some feedback on, you know, you're taking away the ability to try and deal with that type of a situation with your legislation. Can you give me some ideas on why that would be okay or not okay?
Mr. Chair and Senator Osment, what I would do, at least the approach I would take in that point, you know, certainly up to the county board or the city council, would be this does not preclude city councils or county boards or any other unit of government that has eminent domain authority from exercising it locally. You could go through that local option, if you will, for that particular piece of property.
Mr. Chair, if I could add to that, please.
Senator, yes, go ahead.
Senator Osmek, I understand that concern, and it's one thing, you know, if it's a road, it's another thing if it's a park. Park boundaries are certainly more flexible than the direction that a road needs to go. But I will say that has been done successfully in my county, where there was actually a park around some property that was, the owners were not ready to sell it, and it wasn't until I think there was a death in the family, I can't remember the entire sequence of events there, that the county did acquire that party, or that part of the property. So with parkland, it's a little bit more flexible in being able to bring in property as owners choose to sell it. Much different than a road.
Thank you. We have some witnesses who are raising concerns about it. Laird Mork, and then Joe Bagnoli. I'll call up two at a time, maybe. Welcome to the committee.
Yo. Good afternoon, Chairman Marty and members of the committee. My name is Laird Mork, and I'm Park Director in Chisago County. I also chair the Greater Minnesota Regional Parks and Trails Coalition Group organization. Represents cities and counties and nonprofits and individuals across the state of Minnesota. And we're very concerned about Senate File 122 and we request that you do not move this bill forward. Eminent domain is a tool of last resort. I've worked for Chisago County for 30 years and we've used it once. And that was a unique situation where an individual had passed away. There was no family members to deal with. It was on a trail route that we were working on. Our county and city governments, the folks that I've talked to, are very reluctant to use this tool, but restricting its use in this manner will make trail acquisition extremely difficult and expensive. This is the opposite of what the voters wanted when they approved the legacy amendment funding parks and trails. I want to outline a few situations where the restriction is unworkable. Some cities and counties may build trails along roads where MnDOT or another body acquired right-of-way recently using eminent domain. The bill would block using legacy funding in this situation. Acquiring property for trails can take several years of negotiation and thousands of dollars invested in upfront money. I've been involved in projects myself that have taken over 12 years in property negotiations and spent thousands of dollars to acquire these properties, and sometimes there will be one small tiny strip on that corridor where the property owner is not working with us. And that can otherwise block a trail project that would be completed. As cities and counties make use of legacy funds, we hope we do not need to use eminent domain, but we need to keep every tool available to carry out the goals of the legacy amendment. And I thank you for your time and hope you will not move this bill forward.
Thank you for your testimony, Mr. Mork. Senator Brown, did you have a question?
I did. I have a question I'd like to ask Mr. Mork, Mr. Chairman. Mr. Mork, based on what you've just said, do you consider creating parks and trails more of a priority than personal property rights?
It's a good question.
I thought so.
Trying to figure out how I can answer that briefly, but when you consider society's problems and issues with a trend toward plugged-in society, spending time on TVs and computers, obesity, healthcare costs, and all the things that revolve around a lack of fitness and getting outdoors, you have to take in the aggregate picture, and I don't think it's as simple as do you think creating parks and trails, that's not that simple of a question. That's my answer.
Senator Osmick, did you have?
Yep. Thank you, Mr. Chair, for Mr. Mork. So, but based upon what the authors have said, they're saying that the funding here is the trigger, is that if you want to use other avenues for eminent domain, you certainly can use them through other county funds. I know your county certainly has property taxes that they can use for capture of eminent domain. My understanding of this legislation is that would not prohibit any of that activity. That's just that the funding mechanism cannot be through legacy funds. Would you agree with that?
I'm not sure.
Senator, Mr. Bagnoli, or Senator Schmidt, did you have something? Mr. Bagnoli.
Mr. Chair, members of the committee, my name is Joe Bagnoli. I'm with the McGran Shea Carnival Law Firm. I'm here representing the Minnesota Parks and Trails Council. Parks and Trails Council, as some of you may know, is a nonprofit that has existed for, I think, roughly 100 years that promotes parks and trails around the state of Minnesota, has worked with the DNR and other units promoting parks and trails around the state of Minnesota. I spoke with Senator Sengen briefly yesterday about this, and frankly wasn't sure, and have learned a little bit today just sitting here what the issue was. And I think there's an old adage, bad facts, and we have what sounds like a very bad fact pattern sometimes makes bad law, where we're trying to get at a particular problem, although it sounds like the county did address it, and we've proposed sweeping changes that may impact things that we don't necessarily understand. First of all, I mean, it sounded like, frankly, the concern was eminent domain. The property owners that just testified had an issue with eminent domain. The funding stream, as Senator Osmick suggested, there's multiple funding streams that can accomplish eminent domain. So their concern, I don't know if is actually corrected with this. Parks and Trails Council has no formal position on this. We just saw the bill candidly in the last, I think it was introduced a couple weeks ago, but just looked at it recently. However, generally, we're concerned with sweeping policy changes regarding funding tools that local governments may use in relation to local government land use decisions. We're not aware that this issue of eminent domain, other than the 2 instances we've just heard, is a big problem with the use of legacy funds, understanding that legacy funds have only been in existence for a short period of time, but we haven't heard that that's a sweeping problem that's existing in all kinds of places around the state. We know that the DNR does not ever use the eminent domain, or rarely does. Actually, I don't think they ever do. And most units of government don't either in doing parks and trails. I will say all of the parks in I think it was to Senator Osmick, and I think that one of the senators answered it. In most parks, there are in-holdings, meaning private landowners own land within parks. It's the trail issue that is the concern, where you'll have 99% of the people in one trail owner that can't be reached, can't be found, in case deceased heirs, doesn't exist. And that is the odd case where you've made a law that precludes this for that one case, and that's when I say the unintended consequences, or where there's been a eminent domain proceeding for one reason 30 years ago, and now the parks unit wants to buy it for a different reason 30 years later, and it precludes that source of funds, but not other sources of funds. So those are our concerns, that it's eminent domain is seldom used. We have a situation here that clearly, and I appreciated and understood the depth of feeling that these folks have, and that we have a particular instance. It sounds like it was resolved with the county board, but I'm concerned, or we're concerned, at the unintended consequences that frankly we just don't even know what they are right now.
First, any eminent domain proceedings has to be approved at a hearing by a judge. There's always a public hearing before that first step occurs. Secondly, once the acquiring entity makes an offer, that individual always has the option of going before condemnation commissioners if they do not like the offer made by the city, the county, or the state, or whatever the acquiring entity. Thirdly, they're always compensated for their cost of coming up what is the appropriate value of their property. If we're talking about a residence, or what's called a minimum acquisition property, where the value is deemed to be less than $10,000, they're compensated by reimbursement for their own independent appraisal by up to $1,500. If it happens to be a commercial, industrial, or other non-residential property, that compensation is up to $5,000. If the if the original offer, the governmental entity only has one choice at the time that they initiate condemnation procedures to make an offer, they can't change it. If the ultimate award to that property is more than 40% greater than what the initial offer is, the state also, or county, city, whoever it is, the acquiring entity, also has to pay attorney's fees for that acquisition. So there are a number of safeguards within the initial law that speak to this issue. As I said, I think this sets an unfortunate precedent. You've already heard the practical issues that are identified by this. And again, in the past legislature's own deliberations, they've recognized that eminent domain may be necessary in limited circumstances to put together these recreational and transportation assets, and ask you not to pass this bill. With that, I'll conclude. Be happy to answer any questions.
Thank you, Mr. Carlson. Senator Benson, did you have questions?
Thank you, Mr. Chair. Mr. Carlson, I think you should clarify for us, when the amendment that you speak of for Parks and Trails was being brought forward, was it made clear that some of that money would be used for eminent domain?
Mr. Chairman, Senator, I don't think that there was any specific discussion when the constitutional amendment that some of the properties may be acquired by eminent domain, but I don't think anybody was naive enough to think that that may possibly not occur in limited instances.
Mr. Chair.
Senator Benson.
And Mr. Carlson, it's not a matter of naivete. If the voters aren't told some of this money will be used for eminent domain, they can't really make a decision about whether or not it should be used for eminent domain. If you weren't transparent about your intentions, then you contributed to misleading the voter. So I would suggest we take that argument off the table. Voters supported Parks and Trails. They did not necessarily support eminent domain for those parks and trails because, as I recall, it was not clearly a part of the conversation. There are a great deal of landowners who would have been concerned about voting to have their tax dollars come back to buy their land under eminent domain. So please take that argument off the table. And secondly, Mr. Chair, and with all due respect to our testifiers, you talk about one landowner getting in the way of Parks and Trails. Parks and Trails are a public good, that is true. And you talk about all the due process the landowner can go through. One landowner up against all the government entities that you listed, begging and pushing and pleading and taking him to court and filling out paperwork. You've been around here long enough to know how powerful government is. And citizens get fatigued and they just give up. And they give up 100 years of land ownership in their family because they're tired of the fight. Not necessarily because they think it's a good idea. It's our job at this table to deliberate whether taking away somebody's 100-year family land is worth the park or the trail. That's what we're balancing here. And yes, we agree, parks and trails have value. But in the hierarchy, the right of an individual to work for the money, to buy the land, has to have some preeminence where nothing is secure.
I don't know that that was a question, so Senator Brown.
Thank you, Mr. Chair. And Mr. Carlson, I do agree that Minnesotans value trails, but I would also agree with Senator Benson. And when they passed the legacy funds, they did not envision using part of those funds to forcibly take land from someone who didn't want their land being used for trails. And you talked about the needs. Parks and trails are not needs, they're wants. Roads are needs, other things are needs, but parks and trails are not needs, they're wants. And I believe, and this is the position from which I come, is that personal property rights are far more important than the wants of parks and trails.
Mr. Chairman, could I respond?
Senator, go ahead, Mr. Carlson.
There may be a value judgment here as to whether wants or needs come into play, but when individual property owners come into the question of the acquisition of any public property, there's always a question about why do you have to locate it here? Why can't you locate it? And that's true for roads as well as parks and trails. So I don't think that really speaks to the issue. There is a necessity to assemble the property in as most cost-effective and where the amenities such as lakes, streams are available to fulfill the mission of that trail or park. You can't just set it down on a parcel of vacant land where you have a wheeling blyer. As I think everybody here knows, it's lakes, streams, rivers are the preferred location of parks, or where there's some certain recreational or geologic features. You can't undo that.